Welcome to the LexIslamica Law Course video series, brought to you by the Advanced Legal Studies Institute, Islamabad. This course, Islamic Jurisprudence, is the first course of the series. To get a better understanding of the structure and nature of the course, kindly view the course introduction video, the link for which has been given in the description below. This video, The Scope of Islamic Jurisprudence, is the first video of the course. Let's begin. In this video, we will talk about the significance, scope, and subject matter of Islamic jurisprudence, that is, the topics covered by this discipline. During this description, a brief comparison will be made with the scope of Western jurisprudence, which will make it easier for the viewer who is already acquainted with that discipline. Out of all the Islamic disciplines, Islamic jurisprudence is the most important. Interpretation of all types of Islamic texts relies on skill in this discipline. Islamic jurisprudence is important because it is considered a prerequisite for the interpretation not only of the legal texts, but the Quran in general, as well as the sayings of the Prophet, peace be upon him. It is this discipline that spells out the goals, ends, or objectives of the Sharia. It elaborates how discretionary justice is imparted. What that means is that through this discipline, the objectives of the Sharia, called the Maqasid al-Sharia, are derived and after derivation are used for a system of justice. The discipline is also important for understanding the working of the entire legal system as well as its essential concepts. The study of various categories of Islamic law become very easy for the person who develops some kind of expertise in Islamic jurisprudence. Therefore, the subject teaches a student of Islamic law how to discover principles, rules, and essential concepts and to link them all together under the various categories of law. So the Western term jurisprudence in its literal sense means skill in law. The Islamic term for this meaning is fiqh. It is called fiqh in Urdu. The discipline that deals with jurisprudence and interpretation in Islam is actually called Usul-ul-Fiqh, where usul is the plural of asl, which means principle, source, foundation, or root. The title then, Islamic Jurisprudence, was chosen in 1911 when a very good book was written by Sir Abdur Rahim, who was a judge in British India. Abdur Rahim's book tried to map Islamic material and concepts onto an excellent book written on Western jurisprudence by Sir John Salmond. It was a commendable effort indeed. As a result of this mapping, the content and scope of Islamic jurisprudence was influenced to a great extent by the formal structure of Western jurisprudence. The book is still used as a textbook in some institutions. After almost a century, around 2,000 new books were written that tried to move the material back to the actual discipline of Usul-ul-Fiqh. Abdur Rahim's book contained material that went beyond the discipline of Usul-ul-Fiqh and contained a discussion of legal concepts and other topics that crossed over into the domain of fiqh. For example, Usul-ul-Fiqh discusses concepts like legal capacity, rights, but Abdur Rahim's book has included the discussion of contracts, crimes, titles, possession, ownership, property, evidence, procedure, and other topics that belong to fiqh or law rather than Usul-ul-Fiqh. Apparently he did so because Salmond had discussed these additional topics in his book on Western jurisprudence. It is for this reason that Professor Nyazee's book called Islamic Jurisprudence does not include these additional topics, but his book called Outlines of Islamic Jurisprudence does. It is pertinent to mention here that in this course, roughly the first 60% of the videos will deal with Usul-ul-Fiqh. The remaining 40% will deal with additional topics that cover fiqh or law and legal history, including a discussion on schools of law. The efforts made by new books written in English have only been partially successful, as the Western type of course content stands embedded in university and law school examinations in various jurisdictions. In other jurisdictions, institutions have eliminated the title Islamic Jurisprudence and have started using the title Usul-ul-Fiqh, or they have started qualifying the title Islamic Jurisprudence with the term Usul-ul-Fiqh. After the earlier and later efforts, Islamic jurisprudence has come to focus on three things. the formal structure of Islamic law, the sources of Islamic law, and the analysis of legal concepts. These three things are described below. By formal structure, we mean the separation between form and content as explained by Aristotle. The picture of a chair or a table in the mind of a carpenter is the form, while the wood, glue, and nails used are the content. Again, in the Islamic prayer, ruku and sujood are the form, while recitation during prayer is the content. The formal structure of Islamic law is studied under the topic of hukum shari or legal rule. The study covers the following questions. What is the meaning of Islamic law? What is the nature of rules in this legal system? What is legal capacity and how does it interact with the operation of rules? What kind of rights underlie the various kinds of rules? The above questions show the picture or form of the Islamic legal system. There are many ways of classifying sources in Islamic law, but the two broad categories important for the study of sources are the following. Primary sources. Primary sources are those that are unanimously accepted by all the schools and all the jurists as the fundamental sources of Islamic law, those that are binding and must be followed at all costs. The Quran, the Sunnah, and Ijma. Some people include Qiyas under the primary sources, but it is better to classify it under the secondary sources as it is a rational source that relies on the three primary sources mentioned here. Moving on, secondary sources. Secondary sources of Islamic law are those that are not unanimously accepted by all the known schools or all the jurists, that may not be considered binding by all, that mostly rely on primary sources. The reason some people place Qiyas under the primary sources is that it has to be considered binding by all the Sunni schools. This issue will be discussed further in the next video when we discuss the nature of the sources in more detail. A legal concept is a category under which related rules are gathered. For example, the category or concept of marriage will include all the rules related to marriage under it. There are some concepts that apply across the legal system. It is such concepts that are studied in Islamic jurisprudence. For example, the legal capacity of a human is relevant under every law, whether it is civil, criminal, commercial, or another. These concepts include legal capacity, rights, persons, liability, and so on. It is through these concepts that the rules of law are understood, applied, and developed. The subject matter of Islamic jurisprudence, explained above, is captured in the figure below. The diagram first shows that Islamic jurisprudence is divided into three things. Then each of these three things include areas that are studied under them. The formal structure of jurisprudence is the same across all legal systems. Accordingly, Western jurisprudence also deals with the same three things: the formal structure of the law, the sources of the law, and the analysis of legal concepts. Thus, when we look at Salman's book, mentioned above, we find that it has three parts that deal with the subject in exactly the same way. The main or first difference is that the true source of law in Islam is Allah Almighty, while the source of law in the Western system are the people. This means that the source in Islamic law is divine, while in the Western system it is human reason. The second difference lies in the number of legal concepts discussed. Usul-ul-Fiqh discusses rights, persons, that is legal capacity, and liability. It does not include the discussion of concepts like property, ownership, obligations, titles, evidence, and procedure. These are taken up in the study of the main law itself. The human mind works in the same manner, whatever the civilization. Therefore, the formal structures it creates are similar. The major difference in the types of jurisprudence is that one of these relies on sources that are of divine origin.